Hello, everyone. Welcome back to Coffee with Greg, where we talk about all things firearms, firearms policy, firearms and politics, media, culture, you name it. We're talking about it right here on Coffee with Greg. So please take a moment, like and share the program. Encourage your friends to do the same. And on that note, we've already had from the Firearms Policy Coalition one person that you all know. Actually, it was his first time on the program, Richard Thompson. It was his first time on the program, but Cody now, the senior attorney for constitutional litigation. Well, he's kind of a regular.
Yeah, I've been on a couple times.
You've been on a few times. Excellent, excellent. Well, it's good to see you here. How you liking SHOT?
It's been great. It's been great this year. It's been awesome to get around and talk to everybody, to talk about what's going on in the industry, and to talk about a lot of the legal battles that we've been fighting. So it's been a good shot.
Right. Now, do you have you been to a lot of SHOT shows?
I've been to a few. I think this is my third or fourth.
Okay.
So I've got a handful under my belt now.
Right. It's funny. So last year it was a lot fewer people.
It's very quiet.
But it was actually nice because you could actually go to booths, you could actually talk to people. Even some of the exhibitors were like, they actually were able to do more selling and actually sold more product. But
yeah.
This year, a lot of people makes for a fun time.
Absolutely. And it's been cool. One thing I've really noticed this year is that even more so than in years past, people have wanted to talk about the legal battles. People have wanted to talk about the policy. People have wanted to talk about the cases. And so I've had some really good conversations with, massive manufacturers all the way down to, smaller businesses and just people walking the floor. So it's been, there's been a really cool atmosphere from our perspective, or from my perspective.
I think some of that has to do with the decision in Bruin. A lot of decisions that have been made in the past, they're having to now go back and look at. And things that are in the pipeline right now, the Supreme Court is telling them to go back and, okay, well, look, now I know you're still working on this, but make sure you get it right.
Yeah. Yeah, I think Bruin was a big it was not just a huge win in the courtroom, but it was a big culture win. It was something that the gun industry writ large was really paying attention to, and I think people were really paying attention to and trying to dig in and learn what it meant. And then seeing the push post-Bruin, right? I mean, we've been filing cases left, right, and center. We've been going after all sorts of different laws since Bruin. I mean, we did before Bruin was handed down too, but especially since Bruin was handed down. And I think people are really getting interested in that legal side, that policy side, because they realize at the end of the day, if we don't win these court battles, then it doesn't matter what SHOT Show looks like, because if you don't have the individual right to own the firearms that are out on the floor, then it doesn't matter what kind of sales contracts you're entering into.
As someone who lives in California and don't have access to a lot of the firearms that are out there, I know exactly of what you speak. What are you seeing right now in terms of legal opportunities that you see that seem to be? Is there any particular area that seems to be more advantageous right now, or that you see that you're finding yourself filing more cases in?
One thing that we've seen, we saw a big push in and we saw a win in, was the ability for 18 to 20-year-olds to carry firearms in public, right? So Bruin established that the court agreed that there was a right to carry in public. We knew that existed under the natural right of self-defense for ages, but the court finally said so. But there's a lot of states that limit that to 21 plus. Now, those laws are really offensive in particular because when you look at the history of firearm regulation, 18 to 20-year-olds are the reason we have a country, let alone anything else. I mean, 18 to 20-year-olds were instrumental in winning the Revolutionary War. They were key to ensuring that there was a Constitution, that there was a Second Amendment. We had a big win in Texas, striking down their 18 to 20 ban on carry. And I think we've seen other cases kind of follow that, and I think you'll see more and more wins come in that vein. That's been a big one. And then obviously you're going to see a ton, and there's still going to be a ton of movement when it comes to these so-called assault weapon bans, these so-called high-capacity magazine bans, and then sensitive places where you can and cannot carry a firearm if you do have a permit or if your state is a free carry state. So I think you're going to see a lot of action in those areas. 18 to 20 isn't talked about as much, but is really important, and I think is going to be a huge win.
Are you finding that there's one of the things that I've noticed has been more, and it's really more administrative law than it is firearm policy, but the degree to which unelected, unappointed, or appointed bureaucrats are actually within the executive branch trying to write new law and make things crimes that were not crimes and that nobody passed a law to change.
Yeah, that's huge right now, right? So the admin law cases are really big, and you're right, they're not necessarily Second Amendment cases. So when we have those cases, like the framer-receiver lawsuit that FPC has in the Northern District of Texas, it's called an Administrative Procedure Act case, APA. And what the Administrative Procedure Act is it's the rules that Congress set for agencies on how they can issue rulemakings. And so they have to follow these kind of set rules in issuing those. One of the rules is, obviously, you can't issue a rule that's in excess of your statutory authority, which basically means if Congress didn't tell you that you could do it, then you can't do it. Because, right, these agencies are all supposedly acting at the behest of statutes that Congress passed, right? The ATF is allegedly applying the Gun Control Act and the National Firearms Act. But what we're seeing them do is they're not applying the Gun Control Act or the National Firearms Act. They're rewriting it. They're making new law. They're saying things are included in those acts that aren't. And so that's a violation of the APA just as much as it's a violation of anything. And so those cases tend to be a little bit less kind of like sexy when you talk about them, because you're not talking about these like straight Second Amendment challenges, but they're hugely important, and they're very insidious because the agencies kind of bury this lawmaking under this guise of this really convoluted rulemaking process. And so it makes it a lot harder for people to understand and to be able to follow.
Well, and I think it's important that people understand why this is important because, if you have people in for example, the ATF, or in California, you have the Bureau of Firearms making laws. I mean, in California, I think it happens to a large degree because the legislature doesn't really know or understand firearms or firearms technology. They just have this idea of what they want to do, and they say, well, we'll just let the experts make it happen. And it's a laziness on their part. But that then puts it in the hands of anti-gun executives and their appointees to then write our laws. And we have no idea what they're basing it on. We have no idea what it means. And it may have absolutely nothing to do with how effective the law actually is. That whole public process that we're supposed to go through to pass laws is now gone.
Yeah, it's hugely problematic. And what you have is you've got Congress or you have these state legislatures that are intentionally passing vague laws. And the reason that they pass them in a vague manner is so that then the agency can just implement it however the agency wants. But it's easier for Congress to pass a vague law because then they don't have to expend political capital if their constituents don't like it. They don't have to worry about the law itself maybe getting struck down or challenged because it's vague enough that it's up to the agency to implement it. And they don't have to deal with the hard work of actually going through a legislative body and debating out what the appropriate provisions are. So Congress is abdicating its lawmaking function.
Right.
And it's turned into a re-election body, essentially, right? And what they're doing is they're pushing that all to the agencies, but that's hugely problematic because the agencies are meant to enforce law. Right, they're part of the executive branch. Their existence, for what it's worth, which isn't, but is to enforce law, not to write law. But when you're seeing the ATF do this stuff, you're seeing them write new law and then go out and enforce it. So when they get to decide what the law says and they get to enforce it, that violates a fundamental form of liberty of knowing what the law is.
Right.
And it violates a fundamental structure of our system, ensuring that there is a separation of the branches, a separation of powers.
Right. And I said this when we started dealing with bump stocks. And you got a bunch of people who said, well, we don't really need bump stocks. I don't have a bump stock. I don't need a bump stock. And I live in California. They were already illegal in California, but I didn't really want one, didn't really need one because ammo's expensive in California. And I'd be like, okay, there's $100, right? So, but But the thing is, I said, if we allow that administration to violate the separation of powers in order to ban access to a firearm or a firearm part that we don't care about, what's to keep them or a future administration from doing the exact same thing to a firearm or a firearm part that we do like and agree with? I don't know. Center fire semi-automatic rifles that accept detachable magazines that hold any number of rounds, or pistol braces, or suppressors, and that's exactly what it seems. And that's exactly what it seems like the Biden administration is directing or maybe the ATF is directing it themselves, deciding to do it themselves. But that's exactly what they seem to do. Is like, okay, I need you to find a way to change or reinterpret something so that we can get rid of this.
Oh, absolutely. And you see that in the history of firearms regulation. Every process that's banned, before it's banned, whatever practice or whatever item it is, first it's made to be less popular. So the first focus is take it out of the culture and then ban it in a legislature, and then the appetite for people to fight back is a lot lower. So you see this with open carry, right? Open carry became just kind of culturally unpopular. And once open carry was culturally unpopular, cities and states would ban it, and nobody really pushed back because everybody said, well, I don't open carry, that's silly anyway, for whatever reason. It makes you a target, it's provides easier access to firearm, whatever your reason was for it. It made it easier for them to be able to ban that practice. I mean, this goes back decades. This isn't new. And when you see with bump stocks, you can draw a direct line from what the Trump administration did with the bump stock rule to what is happening now with the brace rule. I mean, the ATF hadn't issued a major earth-shattering regulation like this in decades. I mean, it's been a very long time. And so you saw what happened with the bump stock. They're not really popular. They're not really popular in the firearms community except for kind of like a toy that people played with. And there was a tragedy that they pointed to, and they used that in order to push this through. Now, that regulation, we just learned, well, we, again, knew when they passed it.
Right.
The Fifth Circuit sitting on bonk, meaning the entirety of the Fifth Circuit, instead of just a panel of 3 judges, which is the normal, or which is the start.
Right.
That Fifth Circuit sitting on bonk just said that bump stock rule was in excess of the ATF's authority. They can't treat bump stocks as if they're machine guns because they're not. But that rule laid the groundwork for the ATF to issue these kind of big earth-shattering regulations like the framer receiver rule, going after those, industry called 80% lowers and 80% frames. And it laid the groundwork for the pistol brace rule. So that's how these things work. And so anybody that was concerned when that bump stock rule came out and said that it was going to pave the way can point to, being vindicated.
Exactly. And I get that, for some folks, like you said, if it's anything related to the Second Amendment, look, I've always said this is about civil rights, right? And the Second Amendment is a civil right, and we've got to defend it. And even when it's attacked, because we've seen the First Amendment rights of people who want to exercise Second Amendment rights, we've seen those rights go and be under attack. Right to private property, right to due process. I mean, name a right that they have not gone after the gun rights community and said, just because you believe in the Second Amendment, all of your other civil rights are now suspect.
Oh, absolutely. I mean, they go after everything. And I think it's really important to think of all of these things. I would call them natural rights instead of civil rights. But it's really important to look at these natural rights and to understand how they all work together. And focusing on something because it's not necessarily a Second Amendment question, right? So these implicate Second Amendment questions because we're talking about the ability to own certain arms. But there's an important thing that we need to remember, right? If the government doesn't have the express authority to do something, then the government doesn't get to do it. It's not the other way around. If there's the gun controllers like to call these things like loopholes. Oh, they're exploiting a loophole in the law, or if it's not like a private transfer. Right. Oh, well, if it's not regulated, that's a loophole. No, we the people gave the government a certain amount of authority, a certain amount of things that they could do. A fun fact, we enumerated them in the Constitution. If the government can't point to something that says we can regulate X or we can restrict Y, then the government doesn't get to do it. We don't have to justify the exercise of our rights. We don't have to justify the ability to possess property. We don't have to justify our right to defend ourselves from other people or from tyrants. But the government does have to justify its ability to act. And I think that's a really important dichotomy, and that's something that people are really starting to focus on, but we really need to shift perspective there.
Well, you're right, because just looking at California cases, once again, being from California, this is like the first time in history my history that I can think of where the California Department of Justice has actually been required by the courts to justify why they're doing what they're doing. Wait, you don't have, show me where you have the right to do what it is that you're doing. Before it was a given that if the judge, the state didn't even have to come up with a good reason. If the judge just thought there was a good reason, rational basis, then they could do whatever the heck they wanted.
Yeah. And now that they have to try and justify their laws, they're pointing to these blatantly racist and discriminatory statutes that, under today's framework, would be struck down immediately under equal protection under the 14th Amendment. And so you see California publishing this list of laws that they're relying on for support, these historical laws. And all of these historical laws are like disarmament of slaves, preventing people from being able to sell firearms or powder to Native Americans,
or Mexicans, or Chinese,
or Catholics,
or Catholics, right?
Were deemed to be a danger around the founding. They were concerned about like an uprising of the papists. But now that California has to show its work, the work it's relying on, I mean, in effect, what California's saying is, look, we just want to treat you like they treated slaves before we prohibited slavery. Like, I mean, how much more offensive can it be? And they're putting it on paper.
Okay, just so you know, the first time I used that, I will give you full credit. After that, I own it, because you're right. It's like they want to treat us like they treated slaves. That's what they want. That's their legal argument for gun control.
Yeah. I mean, they're pointing to the statutes that disarmed slaves. They're pointing to the statutes that prohibited sales to Native Americans. They're pointing to statutes that disarmed Catholics. That's what they're pointing to justify their gun control agenda. And then they put a statement in their filing that says, of course, we in no way endorse the subject matter of these laws. Well, you're relying on them to support your argument. That's what you're saying. You're saying they give you the authority. And it's garbage. I mean, we know that today those laws could never stand. We passed and ratified the 14th Amendment. We put equal protection into law formally under an amendment. It should have been in there long before that. It should have been understood to be in there long before that. But those laws would never survive equal protection scrutiny.
No, they most definitely wouldn't. And I really appreciate all the work that the folks over at the legal team are doing. How can the viewers follow the work of FPC legal team?
Absolutely. So they can go and follow us at firearmspolicy.org. You can click that legal action button, see all the work we're doing. Once you see all the work we're doing, then go ahead and click the join button and go ahead and support that work if you would. We'd appreciate it. Even if you can't support, we understand. You can follow us on social medias at Gun Policy. Share the wins, share the cases, help educate everybody else, and just follow along with what we're doing. If you want to follow me, I'm at The Wizard of Laws with a Z on just about everything, and you'll get my late night rants about the ATF or gun control. Every now and then I have like a well-reasoned moment about constitutional structure or something, but there's a few ranty moments.
I get this. You have an issue with the ATF. I wonder why.
Yeah.
All right, everybody. Cody Wisniewski, thank you for joining us. Enjoy the rest of the SHOT Show.
Thanks for having me, Craig. Will do.
All righty. All right, folks. Well, hey, that's it for this edition of Coffee with Craig. We're going to be back from SHOT Show 2023 with tons more interviews and fun stuff. So y'all stay tuned, and we'll be back at you real soon.
If you like our videos, follow, subscribe, like, and share.